alone. So when we look at the California Constitution, it's been amended 521 times in 163 years. 521 times. So what happens in California is the cause du jour changes the Constitution, and whether that's relevant or not, on we go with the regulatory process involved in it. Where the federal Constitution has been altered 27 times in 225 years, and 13 of those amendments were on day one, the Bill of Rights. So, and the 3 amendments after that. And even a few of those amendments, people were sorry about afterwards. It's very difficult to amend the United States Constitution. Well, look at Prohibition. That was really a big deal. 3/4 of the states ratified, and within 10 years they thought, gee, this was a mistake. And so they deleted that amendment. But those are the things that keep us safe and keep our liberties safe and protect our ability to make a living, to use property to better the lives of our families. And by the way, all of these things I'm talking about are property rights. Your life is your property. Your property, your ability to make a living on that property, those are things that belong to you, and they should be immutable. How can you conduct your life in the case of a rancher, for example? You're grazing on 10,000 acres, you pay your grazing lease, and all of a sudden someone comes in and says the sage grouse, even though your cattle have been walking around that sage grouse for 100, 150 years, now they're impacting the sage grouse and you need to cut your AUMs in half. How can you conduct your life if you don't know from one day to the next what you own? My water, for example, is adjudicated to my land. However, Fish and Game and North Coast Board, they want the ability to regulate my use of my property. That would be no different than if you have 10 cans of soup in your pantry and someone on Earth Day comes up to you and says, you know, your carbon footprint's too big, you eat too much soup, you need to give me 5 of those cans. Or you'd raise holy hell. You'd never do it, because that's property that you bought and paid for with your sweat and your blood, and you wouldn't give it up. And how could you possibly conduct your life if property was fluid? Property rights are the foundation not only of a rural economy, but of this country, and they must be maintained. So, with Reynolds versus Sims, we start out with Baker versus Carr. That's where the United States Supreme Court gave itself the jurisdiction to involve itself in apportionment and voting districts. And the dissenting justice said that to jump to the thorny thicket involved in these issues is to bury one's head in the sand, and that this will never be a good judgment and it will cause untold amount of harm. Well, the court thought that after Baker versus Carr was settled and they gave themselves jurisdiction over voting apportionment cases in the United States, that any state legislature that monkeyed with that would be afraid of a lawsuit, and so there would be no challenges. 30 challenges later, we get to Gray versus Sanders. Gray versus Sanders was the case where the Supreme Court once again gave itself the power to ignore the Constitution, and they said that all elections in state matters will be one person, one vote. And they hung their hat on the 14th Amendment, Section 1. Everyone's entitled to equal protection under the law. Section 1 was a good law, because what it did was it guaranteed that no person of one race would be hung for a crime that a person of any other race wouldn't be prosecuted for. So that was good law, but it doesn't mention vote. Section 2 mentions votes, but that just guarantees that everyone has the right to vote. It doesn't say that all state elections be predicated on one man, one vote. In fact, Warren not only ignored his own advice later in Brown versus Thompson, but he ignored the Constitution of the United States. Because if one man, one vote were the rule, why does Vermont have 2 senators and Alaska have 2? Why does New York have 2 and Wyoming have 2? Why does the most populous state in the Union have 2 senators and the least populous state have 2? Why do we have the Electoral College if one man, one vote is the constitutional precedent? In fact, that precedent isn't found in English common law, it wasn't found in colonial law, and it's certainly not found in United States law until 1964. Now, when Warren hung his hat on the 14th Amendment, he did something that was very interesting, because there were states that had state senators by county both before and after the 14th Amendment, California among them. In 1926, California had 1 state senator for each county, except counties that were less than 3,000 people, and I believe there were, Sierra County and Plumas were lumped in together. But we had representation by area. Before from 1926 until 1964. California didn't ratify the 14th Amendment until 1959. So if that logic was true, why were states, including a lot of states back in the 1800s, allowed to have representation by county both before the 14th Amendment and after it? Well, I think Warren was trying to accomplish something. And in fact, when someone asked him what was his greatest achievement, he did not say school desegregation. He did not say civil rights. He said, I forced 30 state legislatures to change the way they elect representatives. That was his proudest accomplishment. And the court under Article 3 does not have that power. So here we are today. In 1964, California had about $5 billion in long-term debt. In fact, from 1950 to 1964, it was right around $5 billion. It went up a little bit, down a little bit, but California worked. Because as Warren said, votes don't represent rocks and trees. And he was right, they don't. But votes do represent communities. They represent unique geographical needs. The County of Butte has different needs than the County of Siskiyou. The County of Siskiyou has different needs than Del Norte County. And all of us in rural Northern California have vastly different needs than the County of Los Angeles or Sacramento or San Francisco or San Jose. And we need representation by county so that we can express those wishes, and also there is a check on power. Now, assemblies in every state are simply rubber stamps for their state senates because they're all elected by the same people along roughly the same apportionment lines. We have one state assembly person for every 450,000 people in California. We have one state senator for every 950,000 people. We're number 50 out of 50 in representation. The next worst state only has 130,000 people per state representative. The best state has 3,000. The difference is political campaigns and special interest. In New Hampshire, it costs $1,000 for a political campaign. You pay your filing fee, you fill your car with gas, and you go knock on 3,000 doors. And their turnover is tremendous because when they don't do a good job, you're seeing them in Walmart. And you give them heck for the poor thing that they did, and then you unelect him and elect his neighbor because you can do it, and it's cheap enough, and he has to look you in the eye. I am a pilot. I served in one war in the United States Army, and I've flown airplanes in 6 wars as a civilian contractor for the United States government. And I am here to tell you I have been to every hole on earth, every socialist hole, every revolutionary hole, every place the United States has ever had a soldier. Pretty much since 1980, I've been in 1971 in Vietnam. And what I found in my travels, when you go to the Democratic Republic of Congo, their lives don't work. And they don't work because they have no one that represents them. Here in the United States, people's lives work when they have close representation. It has nothing to do with party. It has nothing to do with agenda. It has to do with the ability of the people to communicate adequately with representation. So once we got past Reynolds versus Sims, the court then ignored its own advice in Brown versus Thompson later, where it said Niobrara County in Wyoming, with only 3,000 people, deserves a state representative because every place deserves representation. And then again in Sawyer versus Tulare Water, the court said that votes can represent rocks and trees, provided it's not done prejudicially and the greater political interest is served. So the part of the reason for this declaration, and the declaration is very carefully worded, it's a declaration and petition to withdraw. What it creates for the County of Butte and all the other counties that have affirmed so far and will affirm is standing in any challenge that comes to voter apportionment and dilution of the vote. If the Board of Supervisors affirms this declaration, you will have standing at a federal challenge of the Reynolds versus Sims cases so that we can create our own state and have representation by county. Also, this is a two-pronged attack. The other attack is, because let's face it, we're not children, we're going to get 10 or 15 of these declarations, we're going to go to the State House, and there's a chance that we'll be ignored, that it'll be rejected out of committee or in some other way. So if that occurs, we'll mount 2 federal lawsuits because we have standing, we've been harmed, we've asked for something and we were ignored. Now, whenever we have standing and whenever there's a harm, there must also be a remedy or the court will dismiss the case. Well, what's the remedy for lack of representation? More representation. Everybody wins in this. And we have several methods of attack planned.